I denied a mother's appeal, and 15 years later, she proved her innocence and sued me. And of all the verdicts I've ever delivered, of all the lives that have passed through my courtroom, the one that haunts me the most is the one I delivered, not with a gavel, but with the simple, cold stroke of a pen. It was a decision that I believed at the time was legally sound, meticulously justified, and procedurally correct. But it was a decision I would come to learn was morally bankrupt, and it cost an innocent woman 15 years of her life in this video. I am not going to share a story of a triumphant legal victory. I am going to share a story of my greatest failure, a failure that taught me that the most dangerous thing in a courtroom isn't a lie, it's a truth that you refuse to see. I'm Judge Chloe Dubois, and after more than 30 years in the justice system, I thought I had seen everything. I thought I understood the nuances of guilt and innocence. But this story, this woman showed me that the weight of a judge's robe is nothing compared to the weight of their conscience. So subscribe and hit the bell because this is a story I have never told before, a confession of sorts, and it is one that every single person who believes in justice needs to hear the name. On the original case file was Sarah Jenkins. And when I first saw it nearly 2 decades ago, it was just one of dozens of files that crossed my desk that month. A seemingly straightforward case of white collar crime. She was a young mother in her late 20s, a bookkeeper at a small but prestigious architectural firm, accused of embezzling nearly $500,000. The air in my courtroom during her trial was thick with a kind of sad predictability. It was a story I had heard countless times, a trusted employee given access to the company's finances who allegedly succumbed to the temptation of easy money. The prosecutor, a sharp, ambitious man named Marcus Thorne, was at the top of his game. He painted a picture of calculated greed, speaking to the jury with a confident, almost theatrical flair. He spoke of a woman living beyond her means a single mother who wanted to give her son a life she couldn't afford, and so she decided to steal it. Instead, I remember watching Sarah Jenkins throughout the trial. She sat beside her overwhelmed and clearly exhausted public defender, her hands clenched so tightly in her lap that her knuckles were bone white. She wasn't defiant or cold like many of the guilty defendants I had seen over the years. Instead, she seemed to be in a state of perpetual, silent shock, as if she were watching a play about someone else's life and couldn't comprehend how she had been cast as the villain. Her eyes would often drift to the gallery where her own mother sat, holding Sarah's 5-year-old son, a little boy with his mother's wide, frightened eyes, who was too young to understand the legal jargon, but old enough to feel the cold dread that filled the room. He would squirm in his grandmother's lap, his small face a portrait of confusion and fear. And every time Sarah looked at him, a fresh wave of anguish would wash over her face, a pain so raw and so real, it was difficult to watch. I listened to the evidence, and on the surface, it was a fortress, a castle of guilt, built brick by meticulous brick. By the prosecution, Marcus Thorne was a master storyteller. He presented bank records that showed a series of small, untraceable wire transfers over a period of 6 months that culminated in one large transfer to an offshore account in the Cayman Islands. An account opened with a digital signature that matched Sarah's. He brought in a forensic accountant, a man with an impeccable resume, who testified that the digital trail led directly and unequivocally to the computer on Sarah's desk. The IP address was a match. The login credentials were hers, and the transfers had all happened during her regular work hours. He explained the complex transactions in simple, easy to understand terms, making the jury feel like they were financial experts, uncovering the crime alongside him. The firm's owner, a charismatic and handsome man in his 50s named Richard Sterling, took the stand and delivered a performance of wounded betrayal. He spoke of how Sarah was like family, how he had trusted her implicitly, how he had even personally co-signed a loan for her car a few months prior. He looked at the jury, his voice thick with a carefully crafted emotion, and said, "I gave her every opportunity. I treated her like a daughter, and she repaid me by trying to ruin the business I spent my life building." His testimony was devastating. It painted Sarah not just as a thief, but as a deeply ungrateful and manipulative person, a viper. He had welcomed into his work family, her public defender, a young man named David, who was barely 5 years out of law school, tried to argue that the evidence was circumstantial. He suggested that someone else could have used her computer, that her passwords might have been compromised, but he had no proof, no alternative suspect, no competing narrative to offer. He was a small rowboat trying to chip away at a battleship, and he was failing with every question he asked during his cross examination of Richard Sterling. He tried to ask about the firm's financial health, but Marcus Thorne objected immediately on the grounds of relevance, and I sustained the objection. It was the correct legal ruling. The firm's finances were not on trial. Sarah's alleged theft was looking back now, that ruling that single word sustained was one of the bricks in the wall of her prison cell. Sarah herself took the stand, which is always a gamble, and in a quiet, trembling voice, she swore she never took the money. She spoke of her love for her son and how she would never do anything to jeopardize their life together. She said she had admired Richard Sterling, that she had been grateful for the job, and that she had no idea where the money went. But on cross examination, Marcus Thorne tore her apart. He brought up her modest salary. And then, with a flourish, he showed the jury enlarged photos from her social media, a weekend trip to the coast, a new television for her apartment, a birthday party for her son, with a bouncy castle in the backyard. He twisted every small joy, every normal purchase into an indictment of her character, suggesting they were the fruits of a secret crime. I remember watching her on the stand, her initial resolve crumbling under the weight of his relentless accusations until she was left with nothing but tears and denials that sounded increasingly hollow. Even to me as a judge, I am trained to be impartial, to look only at the facts and the law, but I am also human. And I could feel the jury turning against her with every passing minute. The story was just too clean, the evidence too neat, and her defense too weak. It took the jury less than 4 hours to come back with a verdict guilty on all counts. I remember the sound that escaped Sarah's lips when the foreman read the word. It wasn't a scream or a cry. It was a sharp, guttural intake of breath, a gasp as if the air had been physically stolen from her lungs. Her mother in the gallery began to sob openly, a heartbreaking wail of despair clutching her grandson to her chest as if to shield him from the terrible finality of that moment. I set the sentencing for 2 weeks later, and as they led Sarah out of the courtroom in handcuffs, she turned and looked directly at me. Her eyes weren't angry, they were pleading, begging me to see something that the jury hadn't. That look had stayed with me long after the courtroom was empty. A silent question mark in a case that felt so definitively closed. 3 years passed, Sarah Jenkins was a number in the state penitentiary, and her son was being raised by his grandmother. I'd presided over hundreds of other cases by then, but hers was a file I never forgot. Then the appeal landed on my desk. It was a thick file filled with the same evidence from the trial, but this time it was accompanied by a 20-page handwritten letter from Sarah herself. Her handwriting was neat, almost painstakingly so, as if she had written and rewritten it 100 times in her prison cell. She didn't just plead her innocence, she argued it with a newfound clarity and fire. She claimed that Richard Sterling, her former boss, had been in deep financial trouble with gambling debts, a fact that never came up in the trial. She alleged that he had been the one to set up the offshore account, and that he had expertly framed her using his intimate knowledge of the company's books and her complete trust in him. She wrote that he had been unusually kind to her in the months leading up to the alleged theft, a kindness she now realized was part of his plan to make her look even more guilty when the truth came out. She begged me to look deeper, to subpoena Richard's personal financial records, to see the story that the evidence didn't tell. I read that letter, and I felt a familiar flicker of doubt, the same profound unease I had felt when. She looked at me after the verdict, but as a judge, my decisions cannot be based on gut feelings or the desperate pleas of a convicted felon. I had to look at the law. The appeal was based on a claim of ineffective assistance of counsel and a theory of a frame-up, but it presented no new tangible evidence. There were no new witnesses, No documents proving Richard's gambling debts, no expert testimony to suggest the digital evidence could have been faked. It was just her word against a mountain of circumstantial evidence that had already convinced a jury beyond a reasonable doubt. I remember sitting in my chambers late one night, the city lights twinkling like a distant, indifferent galaxy outside my window, the appeal file open on my desk. I read through the trial transcripts again, every word of testimony, every piece of evidence presented by Marcus Thorne. It was a solid case. From a legal standpoint, the jury's verdict was reasonable based on what they were shown. My duty as an appellate judge wasn't to retry the case. It was to determine if there had been a legal error so significant that it had rendered the trial unfair, and based on the file in front of me, there hadn't been. Her public defender had been outmatched, yes, but he hadn't been incompetent in the strict eyes of the law. Her theory about Richard Sterling was compelling, but it was just that, a theory without proof. My hands felt tied by the very system I had sworn to uphold. I picked up my pen and I paused for a moment that stretched into an hour. I thought about her son growing up with his mother behind bars. I thought about the pleading look in her eyes. But then I thought about the law, the precedent, the rules that I believed were the bedrock of a fair society. And with a heavy sigh, a breath that felt like it carried the weight of my entire career, I signed the order denying her appeal. The ink felt unnaturally dark on the page, a final, irrevocable period on her story. I told myself I had done my job. I had followed the law. I had done what was required of me. But a small part of me, a voice I tried to ignore, whispered that I had done what was easy, not what was right. That denial was one of thousands of decisions I made in my career, but it was one that never fully left me. Sometimes late at night, I would find myself thinking of Sarah Jenkins, wondering if she was still writing letters from prison, wondering if her son still remembered her face, or if he had grown to believe the story the world had told him about his mother. And then, 15 years after I signed that paper, the past came crashing into my present with the force of a tidal wave. I was retired by then, my days of gavels and robes behind me. I was enjoying a quiet life, reading books I never had time for, and trying to forget the faces of the people whose lives I'd held in my hands. The letter that arrived was not handwritten. It was delivered by a courier, printed on the thick, expensive cream colored paper of a high powered law firm. It was a formal notice and notification of a lawsuit filed against me personally for my role in the wrongful conviction of Sarah Jenkins. My heart hammered against my ribs as I read the words, my breath catching in my throat. Attached to the notice was a news article with a headline that stole the air from my lungs. Mother exonerated after 15 years in prison, as new evidence reveals elaborate frame-up. I read the article, my hands shaking so badly I could barely hold the paper. Richard Sterling, her charismatic former boss, had died of a heart attack 6 months prior, and when his estranged daughter was cleaning out his home, she found a series of old personal journals hidden in a false bottom of a safe in his study. In those journals, he had detailed his crippling gambling addiction and his mounting debts, and then, in chilling narcissistic detail, he laid out his entire plan to embezzle from his own company and frame the one person everyone trusted, the quiet, unassuming bookkeeper Sarah Jenkins. He wrote about how he had used a remote access program to control her computer from his own home, planting the evidence and making the transfers himself. He even bragged about his performance on the witness stand, how easy it had been to feign betrayal, how he had almost laughed when her young public defender had fumbled through his cross-examination. The journals were his confession, a complete and total vindication of everything Sarah had written in her letter to me all those years ago. The letter I had dismissed, the appeal I had denied. I felt the floor drop out from beneath me. The air in my quiet study suddenly felt as thick and suffocating as it had in the courtroom all those years ago. I saw her face again, the pleading in her eyes, the desperate hope that I would see the truth, and I saw my own hand signing the denial, condemning her to another 12 years in a cage for a crime she did not commit. The lawsuit wasn't about money. I knew that instinctively it was about accountability. It was her way of forcing me to face the consequences of my decision, to look at the human cost of a legal system that I had served so faithfully. The next few days were a blur. I couldn't eat. I couldn't sleep. My past had caught up with me in the most brutal way imaginable. My lawyers advised me to fight the lawsuit. They said I had judicial immunity, that I had made a decision based on the evidence available at the time, and that I couldn't be held liable for the jury's verdict. They were right legally. But I knew this wasn't about the law anymore. This was about justice. And I knew I had to face Sarah Jenkins. I instructed my lawyer to arrange a meeting, not as adversaries in a deposition, but as two people with a shared and terrible history. We met in a neutral conference room in a downtown office building, a sterile space with gray walls and a long mahogany table. When she walked in, I barely recognized her. The frightened young woman from the courtroom was gone, replaced by a woman in her mid-40s with lines of hardships etched around her eyes in a stillness that spoke of a long and difficult peace. She was no longer pleading, she was powerful. Her gaze was direct and unflinching, and for the first time in my life, I was the one on trial. I started to speak, my voice hoarse, to offer an apology, but the words felt like ash in my mouth. What could I possibly say that could give her back the 15 years she had lost the school plays? She had missed the birthdays, the scraped knees, the bedtime stories. She was never able to read to her son. She let me stumble through my inadequate words, my pathetic expressions of regret, and then she held up a hand to stop me. "I didn't come here for your apology, Judge," she said. Her voice was even devoid of the anger I had expected, and that somehow made it worse. "I came here because I needed you to see me, not as a case file, not as an appeal to be denied, but as a human being whose life you held in your hands and you let go." She told me about her life in prison, the friendships she made with other women, many of whom were also victims of a broken system. The books she read, the law, she studied relentlessly, trying to find a way to prove her innocence. She told me about her son who grew from a little boy into a man, visiting her behind a glass partition. His childhood anger at the world slowly hardening into a quiet, impenetrable resentment toward her. And the system that took her away, she didn't cry as she spoke. Her words were facts, delivered with a chilling precision. Every word was a blow, a testament to the life that was stolen from her. And I just sat there and took it because I had earned every single ounce of her pain. I had been so sure of my judgment, so confident in the process, and all of it had been built on a lie. A lie I had failed to uncover because I had failed to look this case. This story taught me the most painful and important lesson of my entire career, that the absence of evidence is not the evidence of absence. Just because Sarah couldn't prove she was framed didn't mean it didn't happen. It meant the system had failed to look hard enough. I had hidden behind the letter of the law. When the spirit of the law was crying out for help, I had prioritized procedure over people. And the cost of that mistake was immeasurable. The legal system is designed to be impartial, but it is run by human beings, and human beings are fallible. We have biases, we have blind spots, and we get tired. We make assumptions, and sometimes we make mistakes. But when a judge makes a mistake, the consequences can ripple through generations, destroying families and shattering lives. I eventually settled the lawsuit with Sarah Jenkins. The details are confidential, but the most important part of that settlement was not financial. It was a public statement that I wrote myself, acknowledging my role in her wrongful conviction and apologizing for my failure to look beyond the evidence that was presented to me. It was the hardest thing I have ever had to write, but it was the truest and most necessary act of my professional life. So here is my question for you. What do you do when the system you believe in fails so profoundly? Do you lose faith, or do you fight to make it better? Have you ever been in a situation where your gut told you one thing, but all the facts pointed to another? What did you do? And what do you think true justice looks like? Is it simply following the rules, or is it something more? Let me know in the comments, because this is a conversation we need to have. If this story has made you think about the nature of justice and the fallibility of the systems we put our trust in, then please share it with someone who needs to hear it, and hit that subscribe button. because I have a lifetime of stories from behind the bench, and not all of them are easy, but all of them are true. I'm Judge Chloe. Remember to always seek the why behind the what, and never be afraid to question a story that seems too perfect, because the truth is rarely on the surface. Stay safe, and I'll see you in the next video.